There's not. And it's not. But the work.
All right. Very good. Well, welcome. Good evening, everybody. And welcome in person and also in the land of Zoom. And then this will also be recorded and the link can be sent out. I know there's a lot of people that wanted to be here in person or on Zoom that weren't able to. So tonight will be recorded. We can provide that link to you guys. Just email us at sydney.groen@kw.com. We'll put that in the chat on Zoom for you guys. And if you email us, we'll shoot you that Zoom link probably tomorrow when we get that. And if anybody here too in the audience wants the Zoom link, let us know so we can get that to you guys. So my name is Luke Groen. I'm with Keller Williams, North Central Washington. The purpose of tonight is to educate and learn about the changes that COVID has brought in the landscape of landlord tenancies. So there's a lot of changes that we've seen due to COVID. And there's a lot of changes that we're seeing in real estate. And so we thought it was important to reach out to one of the attorneys here at Jeffers, Danielson, Sonn, and Aylward Law Firm here in Wenatchee. So we have Starleigh Smith, and she's graciously is giving her time tonight and the last several weeks to research Landlord Tenant Act regulations, the changes that have come, and things to be aware of from a landlord perspective. So we feel really fortunate to have you tonight. Would you like to introduce yourself?
Yes.
That'd be great.
Yes.
Thank you.
Hey, I'm Starleigh. I work at Jeffers, Danielson, Sonn, and Aylward, like Luke said. I've been there since June. I moved here from Florida, where I spent 3 years as a prosecutor in Jacksonville. Because the Landlord Tenant Act changed basically right when I got here, I was assigned to figure out what this meant for our clients and for the community. And so I've spent the last 4 months kind of immersed in these new laws and kind of helping our attorneys figure out how they can help advise our clients so that they're in compliance with the laws, and talking with Russ and Luke and Sydney and ECs and all the gang at Keller Williams to discuss these very important changes. So
Yeah, and we've noticed, just talking with our clients and people that we know that are landlords or thinking about getting into landlordship, there's a lot of confusion around it. So even most of us realtors, including myself and Sydney and a lot of leaders here at KW, there's a lot of confusion that we don't know a lot of the answers. So we're still learning. And so hopefully we'll clarify some of those questions that you guys have and educate us all tonight. So
yeah, awesome.
Cool.
Okay, you ready for me to take it?
Take it away.
Okay, yes. So the purpose of this presentation is to kind of teach us this new law from a landlord's perspective. There's a lot of resources out there for tenants. So if you know a tenant that needs help, then there are a lot of resources for him or her. So the big question that we have now is, can we evict our tenants? The short answer is yes, we can. There was a lot of kind of confusion in the news when the Supreme Court struck down the CDC eviction moratorium. A lot of people assumed that meant that the Washington State eviction moratorium also was struck down, and that wasn't true. There's a lot of reasons for that I can go into later if you're interested. But the Washington State moratorium on evictions for unpaid rent expired October 31st. And so that kind of paves the way for a lot of landlords who are dealing with this unpaid rent issue for the last almost 2 years to start taking steps to get paid the rent, to get those tenants out, to get new tenants in who will pay. And before October 31st in Washington State, you could evict for other reasons as well. And so we'll talk about that a little bit further when we get in there. So I think kind of a lot of people really want to know about how to get people out for not paying rent. And when Luke talked about the law changing, the legislature did something really interesting when they changed the law. So they passed a temporary law. It's in effect until I think July 2023 that affects how we evict people for not paying rent. And basically it's the state kind of, trying to think what the right word is. It's the state's plan for kind of smoothing out this COVID eviction process. What they don't want is for everyone to just run to court to kick their tenants out who haven't been paying for 2 years. So they put a lot of procedural hurdles in place for landlords to jump through to be able to evict for unpaid rent. And so we're going to talk about that. So one thing that we have to do now is we have to offer our tenants a reasonable repayment plan if the basis for eviction is unpaid rent. And so what does that mean? Well, the repayment plan cannot be more than 1/3 of the monthly rent charge. So like on here, it says, if your monthly rental rate is $1,500 a month, you cannot charge more than $500 a month in the repayment plan. The repayment plan also cannot go towards unpaid late fees or interest. That was banned under the moratorium, and so you can't retroactively charge late fees for the months that rent was unpaid while the moratorium is in effect. I think that's tripping a lot of people up because in the past you can charge late fees. This applies to homeowners associations if they're trying to charge late fees for maybe unpaid dues. There was another proclamation in effect that basically said you can't charge late fees or interest for any unpaid anything related to housing. There were several proclamations that said that. When we offer our repayment plan, we have to give the tenant 14 days to decide if they are going to accept the repayment plan or not. And then the repayment plan cannot start until 30 days after the notice. So what does that actually mean in real time? Does that mean you have to wait 45 days or 30 days? The way I understand the statute, if you offer a repayment plan on November 1st, you can start collecting the repayment plan on December 1st, because that allows 14 days for the tenant to either accept or deny, and then 30 days before the repayment plan goes into effect. So the 14 days and the 30 days are not consecutive, they're concurrent. So when we send out our notice for repayment plan, we also have to send our tenants this notice that they have the opportunity to participate in an eviction resolution program. You'll see this in the news, on websites, on the internet, referred to as ERPP. That stands for Eviction Resolution Pilot Program. This program initially started in 6 counties on the west side. It was kind of test run throughout the pandemic to see if it could basically help landlords and tenants come to an agreed upon resolution that allowed the tenant to stay in the home and helped the landlord to get their unpaid rent kind of paid back. It's court-ordered mediation is what it is. And so your tenant can decide if he or she wants to participate in the eviction resolution program or not. When you send them notice of it, you have to provide copies to the Wenatchee Valley Dispute Resolution Center if you're in Wenatchee. Every county has their own resolution center, dispute resolution center, that's helping process these programs. So if you have a rental in Snohomish County, Snohomish is going to have a different dispute resolution center. And there's lots of resources on the internet to help people find what the local dispute resolution center is. So this is kind of tricky because in order to get into court, you have to show proof that you mailed this notice, proof that you provided a repayment program to the tenant. And so a lot of people think, you know, I can just go to my tenant and hand him this notice and I can testify in court and that's good enough. Well, it's actually not. And I'm going to tell you why, because you are a party to the suit. So when we have court cases and one party says, I did something, and another party says, no, I didn't, that's effectively having no evidence, right? We need something extra to support or corroborate what someone's saying. And so we get proof of service by either mailing via certified mail or sending a process server. And process server is going to cost you a little bit more, but they provide you with a declaration saying, yes, I hand delivered this, or I hand delivered it to a suitable adult of the right age at this home. And so, you know, a process server declaration is really powerful form of evidence, and certified mail, having that green slip that shows that they picked it up, that helps corroborate, you know, your statement that you sent this mail. And you can take it to court and say, look, I sent it, this says they received it. And if they say, I didn't receive it, that's on them to figure out. But this is an absolute must. You have to tell them about it. So if your tenant refuses the repayment program and refuses to participate in the eviction resolution program, then you can start your eviction process. And so how we start that is we provide them with a 14-day pay or vacate notice. And that starts you on the path towards filing suit in court. And so with a 14-day pay or vacate, it's pretty self-explanatory. They have 14 days to pay you or get out of your house. And then if they don't get out, you're able to file formal suit. If your tenant accepts, then you have to walk through this process with them. If they accept the repayment plan, you have to give them a chance to repay it. You have to let them make their payments every month, and you can't really do anything to get them out earlier for unpaid rent unless they don't live up to their end of the bargain in making these repayment plan programs or repayment plans, payments. If they don't accept your repayment plan, maybe they think that 1/3 is too much. They can't afford it. They're trying to get you to reduce the rent, or they feel like less would be something that they can do, but they can't do the full 1/3. And you guys go through the eviction resolution program and you still can't come to an agreement, then you can move forward with this eviction suit, the 14-day pay or vacate. If your tenant defaults or you can't proceed, then you can go to Superior Court. There is another process, and it's this landlord mitigation program. And I don't know if it's getting a lot of advertisement, but it's actually a really interesting program. It's through the state of Washington, and I can provide Luke with links to the website afterwards that he can disseminate. But basically, if you have a tenant that's in your unit, your dwelling, your house, you've agreed to a repayment program and then they can't do it, you can ask the state of Washington to pay back this unpaid rent up to $15,000. But you have to jump through these hoops before you can ask the state of Washington to do it. And so what this program does is it makes landlords whole to up to $15,000. And then you have to agree that you are not going to go after the tenant for anything over $15,000 or the payment. Basically, you can't double dip. You can't get money from the state and then try to go get the same money from the tenant. And I don't know what the timelines are for getting payments. I I can't speak to how long it would take you to get it. But the idea is that landlords get the money they need, tenants get to stay, and everyone wins. That's the idea. I don't know in reality if that's how it works. So I guess I just covered all of this. The money in the landlord tenant I thought was interesting, covers unpaid rent that accrues between March 1st, 2020 and December 31st, 2021. If you have a rental that's renting for $2,000 a month, $15,000 isn't going to come close to what's owed. So it's up to you as a landlord to decide if something is better than nothing. But this resource is available. So those are kind of the procedural hurdles for evicting for unpaid rent. And I don't know, Luke, if it would be good to take questions about that process before we go.
Yeah, I'd say, I think it's all right if you guys have questions here in person or on Zoom, we can open it up. Questions on Zoom. Cindy, you can monitor the chat box in there. I think that'd be the easiest way. Yeah. So if you have a question on Zoom, just state in either your question in the chat box or say that you have a question, you can speak up.
Okay. And we had a question here.
Yeah, it might be common sense, but the part that I missed was, okay, so they're gonna pay back that portion.
Yeah.
So that's while they're now paying full rent as well.
Paying
So
full
it's on
rent.
top.
Yes.
Okay.
So in theory, if your rent is $1,500 and they're paying back $500 a month, they're paying $2,000 a month. And it's the $500 is going towards unpaid rent, the $1,500 is going towards this month's rent, and the repayment plan cannot go towards late fees, like I said earlier. Did you have a question? No?
I have a question, Starleigh.
Yes.
I think if you go back like 3 slides,
Yep.
I think it will jog my memory. There was an or question, or yeah, right there.
Right here.
If your tenant defaults on the agreed upon repayment plan, you may proceed with eviction to Superior Court, or you can try to recover unpaid rent. So say they're doing the 15 is their normal and then 500 on top, and they just can't keep up with that.
Yeah.
So if I want to just be done with them, I can evict. If I don't, then I can keep them paying the 15 and then try and get my leftover that I'm still missing
Yes.
from, okay.
Yes.
Okay.
Yes.
I guess I answered my own question, but
Yeah.
I just needed to talk through that.
It's really dense. It's really dense, and it's like totally okay to have questions about it, because I've been studying this for 4 months and sometimes I get tripped up when I'm reading it. Like, oh wait, hang on, okay, yes, I have to walk through this process. What a lot of people don't know is how the eviction proceedings work. And I can touch on that, like a brief timeline of what that looks like for you guys if you're interested, because it's not as simple as saying, hey, pay me rent in 14 days or get out, and then we go to the court and they get out the next day. It takes time.
Amanda on Zoom asks what happens if a tenant has a repayment plan, but then moves out with a repayment balance. So they move out before they're completely paid up.
Yeah, so if that happens, then you can turn to the landlord litigation program. So under that program, if your tenant has this repayment program and they just leave, right? They don't tell you, they just pack up and move out one weekend. And it's not because you were threatening eviction, and it's not because, you were, threatening their dog or whatever, then you can go to the landlord litigation program and they can help you try to recoup some of those costs. Yes.
So the 1/3 payment cap, is that based on the frozen rent that we're due during the pandemic, or is that get to be raised to new rents currently, because you couldn't raise rents previously?
Yeah, so that is a good question that we'd probably have to look at the actual facts of your case to figure out exactly what that means, but the statute says 1/3 of the regular monthly payment. So if you are negotiating on a monthly payment that you've agreed to, then 1/3 of that. should be
So-
well within the bounds of the
So it's
law.
whatever's really worth the vacation.
Yeah. Okay. So a lot of people.
Have a question?
Oh,
Yeah.
yeah.
So if your lease expires during that,
Moratorium,
yeah, the moratorium, or not the moratorium, the repayment program,
sure.
and the tenant decides not to release the unit, what happens then?
So that gives us, that takes us into this land, right? These other grounds for eviction. Because the leases in Washington are gonna determine your ability as a landlord, like how you go about getting it out. So if you have a lease with your tenant that says, this lease is good for 1 year, and after 1 year, you have to renew your lease for another 6 months or 12 months in order to stay in this house, then with notice to your tenant, you can raise the rent, you can re-sign the lease for 1 year, or you can tell them, hey, I don't want to lease to you anymore. You're gonna have to move out at the end of the lease. And that's a 60-day notice at this point. Most leases in the state of Washington have a clause that says after 12 months, this lease rolls over into month to month. And it shall be month to month forever and ever until we decide it's not going to be month to month anymore. That clause puts us into some tricksy ground with the new statute. And so that's what the legislature spent a lot of time doing over this last legislative session under cover of COVID. So they decided that if you want to end a lease, that you have to have cause. Oh, I don't know what that, I know what that means. And it is complicated. So you have to have cause. The state has required landlords now to find one of 16 reasons allowed by statute to end a tenancy. So what does that mean? Well, if you're just tired of this tenant because maybe they're loud, but not loud enough to disturb anyone, just loud enough to be loud, or they're, don't cut the grass the way you like the grass cut, or, they don't keep the house as clean as you want it to, but there's nothing kind of legally wrong with what they're doing. You can't really just get rid of them. You can't just decide, I want someone else to live here. You have to tell the court why you don't want them to live there anymore, and it has to fit within this list of reasons that they say is allowed. So there are some exceptions to this, and one of those exceptions is if you have a lease that expires after 6 or 12 months and requires a renewal for another fixed term. Those kind of leases you can just end at the end of the term. But these month-to-month ones are tricky. Do you guys have one of those nice leases?
I'm about to.
You're about to. You're a smart man.
Moving forward.
So that was pretty much Russ's exact question in the chat. So I asked if that covered it, and he says he thinks so. But yeah, it sounds like there's kind of some,
Yeah,
it depends on the situation sort of
yeah,
answers.
yeah. Kind of the poison pill in a lease for a landlord is letting it convert to month, right? That's what ends you up in this tricky spot. Now you can have a lease that says at the end of 12 months, we convert to month, and if you're paying attention and at the end of 12 months, you decide, I don't want to rent to them anymore, I don't want it to convert to a month-to-month lease, as long as you provide them with 60 days notice before the end of the term that you're not going to renew their lease, you can just be done with that. But that requires you as a landlord to stay on top of your game, to decide at month 9 if you want to renew a 12-month lease, right? because you have to give them notice at month 10 that you're not gonna let them stay past 12 months. That's the only way out kind of this mess. If you have a lease that converts to month to month. So this is not inclusive. I left some reasons off because some of them just don't apply to the landlords in this room, right? Like one of the reasons was the tenant doesn't abide by subsidized housing rules or program requirements. I don't think that East Wenatchee city attorney is here asking me for how he can get subsidized housing tenants out. So I left that reason off. There are 16 reasons that a landlord can choose to get rid of a tenant, okay? The ones that I've seen that are most popular kind of coming through our firm are waste and nuisance reasons. The owner intends to occupy or the owner intends to sell. Those are kind of the three most common reasons for evicting a tenant that I've seen. And each of them has different notice requirements. Each of them has different kind of statutory thresholds that you have to meet. So notice requirements is something required. Notice is what's required by the statute so that you give your tenant enough notice legally that they have time to find somewhere new to live, to find a new landlord, to get their stuff out. And landlords need to be very careful when navigating this new statute because you have to pay very close attention to how you notify your tenant that the lease is ending. Because there are penalties to doing it wrong. So each cause has its own notice requirement, and I kind of broke it down based on the different ones. So if you have a tenant that is committing waste or nuisance or engaging in unlawful activity on the property, you can give them 3 days notice to quit. And so basically that means you have 3 days to get out. And then after that time, you can go to the court if they're not out and start this unlawful detainer action. When we go to court, and this 3 day notice to quit, the reason I talk about it in this one is because when you have a tenant that's wasting your home, do we know what this means legally, waste? So waste under the law is when the tenant is damaging your home, when it's not just failing to cut the grass, it's putting holes in your walls, damaging your flooring so that you have to replace it, causing fire hazards, things like that. When you have a tenant that's committing waste, you have a real quantifiable reason to get your tenant out. And there's usually a lot of kind of stress that's surrounding this process. Like, I need to get my tenant out because I need to take care of my investments. But it's not just as simple as 3 days. After 3 days, you can file the complaint. And then it's usually about 3 weeks before you can actually get into court in front of a judge. It's 2 to 3 weeks, because once you file the complaint, you have to give the tenant that complaint and they are allowed time to answer and respond. And so a 3 day notice to quit can turn into 6 weeks before the tenant is out. Because if they respond and they have a defense, then a judge is likely going to give them a trial, which is scheduled within 30 days of the initial court date since they're still in the home. And then at the end of the trial, you either lose as a landlord and they get to stay, or you win and the writ of restitution is issued, which you take to the sheriff, and then they go through the process of getting the person out. So it says 3 days, 10 days, really from the date of this notice, you need to add this much time plus probably 6 to 8 weeks to actually process through the court system and get the person out. It's just how it works. I mentioned this a little bit before. Notices must be served by someone who's unrelated to the case. Now, often when a notice goes through a law firm, it's through a process server, which we talked about earlier. But I've seen like property management companies, they have someone who is unrelated to the case who delivers this notice and kind of attests that, hey, yeah, I delivered this notice to the person. I posted it on their door, taking a picture, posting it on the door. The statutory requirements for delivering notice is very specific. And so if you're gonna do this on your own as a landlord, you need to go to the statute, and I'll tell you what it is. It's RCW 59.12.040 and follow it with exactness. Because if you don't serve notice correctly, the court will throw your case out. Because this notice must be followed. And then there's case law that says the notices must be specific. So what we see when specificity, the cases that I've read when specificity comes into issue, it's generally in cases where you have a tenant that is breaking the law or causing problems for other tenants, and that's your basis for getting them out. What the court wants the notices to include are dates and names of people that were hurt or bothered or frightened in some way, because what the court wants is the tenant to be able to mount a defense. And so if they don't know what dates you're talking about, they don't know how to defend themselves. And I've read several cases where the court has thrown out unlawful detainer suits because the notice was not specific enough. So if you have a case where you have a tenant that is causing problems for neighbors, it may be best to run any notice that you are planning on sending by an attorney to make sure it's specific enough. Because the court is very clear. If it's not specific enough, you do not pass go. Okay. And do we have any questions about that? That's a lot. It's super dense and it's a lot. Yes, ma'am.
We have a tenant who their lease is expired and they continue to use it used to be for selling the property. And it's a condition of selling the property that these tenants are leaving. They're not home, they're in a lease spot.
Oh,
So, and there was no formal lease. There was a you can stay here for 2 months if you pay yada yada yada.
Yeah.
You gotta leave by this date.
yeah.
Well, now they won't leave.
Yeah.
So what do we do in a case like this where there's no,
So
it was a cash payment kind of a thing?
Yeah.
So are they trespassing at this point?
well, you need to talk to an attorney specifically about your case, but I can tell you that because that your case probably triggers a different statutory act called the Mobile Home Landlord Tenant Act, which is a little different. But an attorney would have to look at it specifically to help you through the facts. There are ways to get them out. But it's probably a little too specific for this meeting. Yeah. Definitely. I mean, there's ways.
Yeah.
But we can't dive into it here.
Yeah, I'm glad you brought that up because there are some unique tendencies, situations. For instance, living under the same roof in the same dwelling as somebody, that falls into some different classifications in the Landlord Tenant Act than just renting out the whole house or an ADU on the property. So really, yeah, sometimes it does get kind of into the specifics of, okay, what is the situation? Let's look at the facts. And that's where Starleigh or anyone at law firm will be able to look at that.
Yeah.
So,
Yeah, if you share a dwelling, you're actually kind of in this really great sweet spot because you just have to give them 20 days notice before the end of the term. Yeah.
Is that shared dwelling with like if you're in a multi-family, you're in one unit and they're in a different fall under the
No. So under the statute, to qualify for a shared dwelling, you have to share a kitchen and bathrooms. So this one's kind of easy, right? Like if you have people sharing your house with you, maybe you rent out a room and it's month to month, then what's today, November 9th? If you wanted them out by December 1st, you would have to give them notice by tomorrow. Because it's 20 days notice before the end of the term, not just 20 days notice anytime. So you have to time your notice within the month based on what type of tenancy you're ending. And that's why it's really important to talk to an attorney, because some of these are just 3 days, we don't care when the notice is. And some are 20 days before the end of the term. And so you just have to go to the statutes. And this statute here, if you want to write it down, that talks about all of these, is RCW 5918.650. It's 59.18.650. It's super dense, and you're going to want to poke your eye out once you're done reading it. But it's got all of this in here, and it will point you to the notice statute that tells you exactly how you have to deliver these notices. I don't recommend being a do-it-yourself eviction person at this point in this day and age. Just because one thing also that I didn't add to my slides, under the new Landlord Tenant Act, the state basically has created a public defender for tenants. If you're an indigent defendant, which means you're below a certain income level, you get a free attorney to help you fight an eviction. And so where in the past as a landlord, maybe you could do it yourself and it was fairly straightforward and you just follow the statute and you go to court and you do all that. Now it's going to be you, if you don't hire an attorney, on your own against an attorney, which kind of messes up the playing field a little bit. So, you know, just something to think about, especially if you're renting out low income housing. The free attorney is only given to indigent tenants. So if you have, like I rent my home because I just moved here. If for any reason I was being evicted, I would not qualify for a free attorney and not indigent. So something to keep in mind. Yes.
What is that?
I don't know specifically. Usually it's like 150 or 200% above the federal poverty line, but you should be able to find that online pretty easily. It's basically low income. There aren't a ton of people. In my experience as an assistant state attorney, which isn't super applicable, but in the sense that I saw people who qualified for public defenders and people who didn't, there are not generally a ton of people coming through the system in this way that don't qualify for public assistance. The vast majority of criminal defendants are low income. And I would imagine a lot of the tenants who are going to be evicted for unpaid rent or waste, or nuisance, they're probably going to be low income. And that's not a commentary or political comment, it's just observations. So some helpful information. Russ was, kind of gave some rapid fire questions that he thought people might have. So I kind of incorporated them a little bit into this. A lot of landlords think that if their tenant doesn't pay rent, they can shut off their power. You cannot. In fact, you will get in a lot of trouble if you do that. A lot of landlords do not know that they might be responsible for the tenant's unpaid utilities. And you would think that's a secret. It feels like a secret, but it is on the PUD's website. You can find a page for landlords that talks about how you are responsible as the property owner for your tenant's unpaid utilities. And if you let utilities get turned off, you can get in trouble with the law. So it's something really important to keep in mind. There are some instances where you won't get in trouble if the PUD doesn't notify you. But again, that's very fact specific. And so if you find that you're in a situation where power might get turned off, might not, and you don't know what to do, you should call an attorney. Did Rush just have a question?
Yes. He says, if the lease expires with a month-to-month provision that states it rolls into a month-to-month tenancy, how does the landlord raise rent? Does the tenant have to pay subjective higher rate at landlord's unilateral discretion or not so much?
So the statute, the new statute has a provision in it actually for landlords that may be very helpful for you guys. So anytime within the institution of this new law and 3 months following the expiration of the moratorium, so it expired October 31st, so January 31st, you have the ability to convert any leases you have with this month-to-month provision into a fixed term. And so the statutes are specific about how to do that. You have to provide the tenant with notice that you want to convert this into, you want them to sign a new lease. And then if they refuse, then that gives you grounds for getting them out. But it's a limited window that you have. So if you're in that situation right now where you have a month-to-month tenancy that you're landlord of, and you kind of want to avoid all of this, it may be great to talk to someone to start that process of converting the tenancy over into a fixed tenancy that expires at the end of 12 or 6 months, that requires a 12 or 6 month renewal, because then that keeps you out of this for-cause termination confusion. I don't know if that answered Russ's question, but there's a process within the statute for raising rent, for converting rental agreements. It's just buried in there. It's very fact specific. Okay, this is kind of the way that the legislature has decided that they're going to make sure that landlords don't just skirt around the edges of this statute. And they have fixed penalties for noncompliance. Now, the penalties are different based on different things. Generally, this is the penalty, but I can tell you specifically that if you are trying to evict a tenant because you want to sell your house, right? And it's a little different because you're selling land. Let's say you're selling a house and you wanted people out before you put it on the market. That's a 90-day notice. And then at the end of the 90-day notice, if they leave, the tenant, if they watch and they see that within 60 days, you don't put the house on the market at a reasonable rate with either with a realtor or on your own, they can take you to court for unlawful eviction and they can get damages from you. And so, when you read this, you think like, oh my gosh, my tenant can sue me. Well, yes, that's true. But realistically, thinking about this, a lot of things have to line up, right? One, you have to actually not get the house on the market. Two, you have to have a tenant who is paying attention enough to see that you don't get the house on the market. And a tenant who's petty enough to take you to court for not getting the house on the market. And then once you get to court, you have something called a rebuttable presumption. So it's not a slam dunk for the tenant. They can't just go to court and say, hey, he kicked me out because he was going to put the house on the market and then he didn't put it on the market, give me my damages. He can say those things, but then you say, wait, judge, I had to replace all the floors and there's a staffing shortage, whatever your reason is for not getting it on the market on time, you go to the judge and you tell the judge. And then the judge makes a determination if the eviction was lawful or unlawful. But it's a big hassle and pain in the neck. Because no one wants to have to go to court and defend themselves for managing their own property the way they want to. And so this is really a really important part of this new landlord tenant law that landlords need to pay attention to, because financially you are on the line if you choose some bogus reason to evict someone and then that's not actually why you're evicting them. Tenants can come back and bite you for that. Oh, that's the end of my slideshow. Do we have any? Aww. Do we have any questions? I'm that good.
Yeah.
So what?
So I have a question.
Yes.
I'm in the finance industry, so I work with the financial end intimately with buyers and sellers and people that own rental properties. And I have cases going on now that are actually being with the courts over on the west side.
Yeah.
My question is, because I was very familiar with the Tenant Landlord Act, that every time I would finance a property and I knew people were buying it as an investment property, I gave them that booklet. I wasn't required to, but I just wanted to educate them. So that all, it sounds like, got thrown out. And of course, that was pre-COVID. Now this is in place. So
Yeah.
this isn't specifically just because of COVID. This is like,
This
No.
is new.
right, this is our whole, in the state of Washington now, we have a whole new act for the relationship. Are they gonna publish a booklet again, like
don't
they did in the
know.
past? It was pretty handy to have, like, you know, in finance, everybody gets a lead booklet and all the rules and the regs and all that.
Yeah.
I'm just curious because to me, it almost, and I've been talking to realtors, it's like, who in their right mind would ever want to be a landlord? You know, on the small time, and I keep wondering, is there a conspiracy out there? Not a bad conspiracy, like something nutty,
Yeah.
but is there a move on the part of real wealthy corporations and stuff to basically want to put folks like us out of having a little income, having a rental property or 2 or 3 or 4, which a lot of people do.
Yeah.
So these corporations could weather the storm with this crap because they have deep enough pockets.
Yeah.
And they could literally have attorneys on retainer to deal with this BS.
Yeah, I don't know about that.
Yeah,
I don't
so-
know what the back and forth was that led to this, and I haven't heard about a book and I haven't seen a book, but maybe it's coming.
I just think the mom and pops are out of business now.
I think
Who
a
would
lot
wanna go
of
into
people, yeah, I think a lot of people agree with you, and I think, I mean, the realtors in the room would know better than I do. I love to watch real estate. I look at my realtor.com app
Yeah.
at least once a day. And I've seen a lot of low-income housing come on the market that I assume used to be rentals. Some of them say investment property, tenants already there. And I just think, oh, these poor buyers. So I think a lot of people feel the same way you do, that they don't want to be in the rental business anymore.
Yeah, and I'm glad you brought that up. I mean, it's gotten, obviously, being a landlord today has gotten a lot more complicated than it was. There's a lot more hoops to jump through and a lot more things you just need to be aware of. So, I mean, glad you mentioned the state statute. Yeah, get your highlighter and your pen out and underline things that are applicable to you and steady up on that, because it is complicated, but I think today we do have this higher obligation and responsibility to understand what being a landlord is.
Yeah.
So.
Yeah, and go ahead.
Well, you mentioned 6 and 12 month leases
Yes.
that don't have to apply to the same restrictions that the month has.
Yes.
Is that either or? It has to be at least a 6 months? Could it be a 90-day lease?
So the statute talks specifically about 6 and 12 months. And when you read case law about statutory interpretation, the courts have said that the statutes will be strictly construed. So basically, what you see is what you get. And so if the legislature wrote in 6 or 12 months, generally that's what they mean. And if they meant 90 days, and they would have written 90 days, if they meant whatever. I don't think that you would probably have a problem if you negotiated for a lease between 6 and 12 months, like a 9-month, because it's kind of between those two. But I think you potentially could run into problems defending a fixed term lease for 90 days.
My logic is for renting somewhat like a short-term rental,
Mhm.
but to like traveling nurses, for example,
Yeah.
where it's not just 1 month.
Mhm.
It's a set, usually 90 days, but most
Yeah.
landlords now do it as a month-to-month for 3 months.
Sure.
And so that's where,
So Washington State itself is kind of moving in its own direction with these Airbnb short-term rentals. I'm sure you guys have heard Chelan County, the unincorporated areas, they've got this whole short-term rental act code. It's code that they've passed that kind of restricts a lot of things. So if you have a short-term rental, it's probably different than residential, but you should talk to an attorney about your
right,
specific.
well, technically this would specifically for like traveling nurses.
Mhm.
The short-term rental code doesn't apply because it's more than 30 days.
The medium term.
Right, and so, I know it's
Yeah.
that gray area no one really wanted to talk about.
Yeah, it probably is that really muddy sweet spot where you do get lumped into this landlord tenant act. One thing you need to know is the statutes are very clear in any lease you sign. You cannot ask your tenant to waive any rights under the landlord tenant act. So if you're asking your tenant to waive notice requirements, to waive notice requirements is the thing that's coming to mind, like, that is not going to be enforceable. The court will not support you enforcing that. And they'll kick you out and say, you have to give the right notice. You can't just evict because your lease says you can. So the legislature's gone to great lengths to make sure that people cannot contract away their rights, that they can't, be coerced out of housing. Sometimes you'll hear the phrase cash for keys, and it's basically a way of negotiating a resolution short of filing an eviction against a person. Because when you evict your tenant, that stays on their record and it's bad for them. So they have incentive to negotiate also. But you have to have a reasonable tenant who understands that an eviction is bad for them in order to do that. And you have to sometimes be willing to pay your tenant to leave. And some people are not okay with that. It's a risk benefit analysis that you'll have to perform. So
Eric asked, what's the statute regarding notices?
59.12.040. And I can tell you the statute in Florida that makes meth illegal too, if you guys really want to.
No, thank you.
Okay.
Unless we're investing down.
Could you see the shock on her face after every time you start rattling off the numbers in the county? She goes back.
It's this magic that I have, when you spend a lot of time studying things, sometimes it's just faster to memorize it than to constantly be looking it up. So I don't know every statute in the state of Washington, just a few. Yeah. So. Do we have any more questions? Well, great. You guys have been wonderful. Again, my name is Starleigh Smith. I work at Jeffers Danielson, Sonn and Aylward. We have lots of wonderful attorneys in our firm, but just in the Wenatchee Valley, there are lots of attorneys who are really wonderful and have lots of integrity and who would love to help landlords with these issues. If you get confused, if you feel like you're in the weeds, it's probably better to spend just a little bit of money to talk to an attorney than spending money to pay off your landlord under a court order or your tenant under a court order. So thank you guys for your time. I appreciate it.
Thank you.
All right, thank you so much.